next matter to come before us this morning is State of Ohio versus Gracshawn Thomas. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve some time for rebuttal, if you let me know when you get started. I'm keeping the clock this morning, and we'll keep you apprised of the passage of time. The court has read the briefs, and we are ready to proceed when you are.
Yes, good morning, Your Honors. I am Gary Levine. Excuse me, I am counsel for Gracshawn Thomas. Procedure, and I do wish to reserve 5 for rebuttal. Your Honor, not in any particular order of argument, but I would like to start with the second assignment of error, and I defer to the court's recollection of the facts. I'm going to use my time to do that. But in summary, in the manifest weight argument, it is clear that the evidence against Gracshawn Thomas was circumstantial. We could see that, and certainly the law permits a conviction based upon circumstantial evidence. However, the evidence that was adduced against Mr. Thomas was insufficient as a matter of law. It was sufficient to get by the criminal Rule 29 motion originally and as renewed. What we have is a lot of testimony, numerous pages in the record, as to the identification of the appellant, which was ambiguous at best. No one positively or even distinctively identified Mr. Thomas as being present. The state used much of its case in numerous pages in the transcript to establish the presence of Mr. Thomas in the vicinity of the homicide by virtue of testimony of various technicians and experts in cellular phone. And frankly, it was difficult to follow. But essentially, what we have is testimony by the experts who put the user of Gracshawn Thomas's listed phone numbers, this is subscriber information, in the vicinity of where the drive-by shooting occurred. As a matter of fact, the defense introduced the testimony of the expert himself, who indicated that the subscriber may have been, or user of that phone, may have been on the expressway. He may have been in the vicinity. Certainly does not provide credible evidence to establish the presence of Gracshawn Thomas. Combining that with his there were alibi witnesses who testified that he was elsewhere when this homicide occurred. We also, there's one person that provides any identification, and that itself was somewhat inconsistent with the testimony of other witnesses who saw him by the subject. It was a Buick Rendezvous, cleaning it out. There was an explanation given why. He admitted that he had purchased marijuana that morning and realized he dropped it and was fishing around in his car. There is absolutely no forensic evidence to link the death of Mr. Golden, the victim in this case, with Gracshawn Thomas. The police even went to the extraordinary length of going out to the area where Mr. Thomas was reportedly and admittedly where he was cleaning the car with Del Rico Thomas, the co-defendant. They even cut down bushes, used a metal detector to see if there were any shell casings or anything of any evidentiary value. Nothing was found. So we have testimony consisting of a less than positive ID, and we all know that so-called eyewitness testimony has been proven to be unreliable. There's a question of whether he was even there. There is no testimony, there's no witness that says they saw the defendant, the appellant, other than at his home or the home of a relative where the vehicle was cleaned. Now, he's also charged with the tampering. What they found was a vehicle that was burnt. There's no linkage to him. So certainly in every criminal case, we have requirement of proof beyond a reasonable doubt. In this case, we have isolated bits of evidence that may put him where the drive-by occurred, puts him cleaning the car later. We have ambiguous cell phone records, which obviously there's no content of the conversations. We have pinging off of various cell towers, and we suggest that is insufficient as a matter of law.
You're not questioning the reliability of the pings. You said there's ambiguous evidence.
Well,
The pings either are established to be off a certain tower or not.
Well,
You conceded that?
We conceded that the technology is what it is.
Okay.
However, the witness that testified for the defense indicated that it goes to the strongest signal, not necessarily the closest signal. So we have a phone number.
I understand that.
Okay. So we're not questioning, there was sort of a refinement, if you will. The other issue, and I think is frankly paramount significance in this case, is the issue of whether the trial court erred, and we suggested respectfully that it did, by admitting the testimony of the companion friend, I don't know if it was common law wife, Marcella, who was permitted over defense objection to testify as to the purported fear of Mr. Golden as to Gracshawn Thomas and another individual. I know the state has argued in its brief that there was a waiver because purportedly the defense did not properly preserve that issue for appellate review. I suggest otherwise. This is clearly a confrontation issue. We have essentially the victim testifying, in quotes, from beyond, from the grave, that he feared Mr. Thomas and others. There was a properly and timely filed motion in limine to preclude the testimony, and the state has argued in its brief that that was waived. Certainly, the whole basis of the rule against hearsay is based upon the Sixth Amendment confrontation right. That was violated in this case. And if you observe look at the argument made at the beginning of the transcript in furtherance of the appellant's motion in limine, the court expressed concern that this would in fact be hearsay. Clearly, you can't cross-examine the person who has died. There's also some suggestion of a forfeiture because the witness was prevented by the actions or the statement of the appellant. We suggest there is no such forfeiture. We basically have the state faced with how do you get in the testimony or the alleged state of mind of the victim. Obviously, he's not here to testify. And the court appropriately expressed concern, and then the state went on and did exactly what the defense objected to. It allowed, under the guise of a present sense impression, the testimony, if you will, the statement of the decedent. It clearly violates the appellant's confrontation right, and we suggest that is virtually impossible to overcome. the damage to the appellant is manifest. I mean, we clearly show it's hearsay. There is no reasonable, reliable basis for exemption or any way that it could be found not to be hearsay. It's not a present sense
If I may, weren't these statements made at the time, at the location of the homicide? And the statements that were made by Ms. White were made at the location at that time, correct?
I believe so. I don't recall specifically, but they're in anticipation of that argument by the state at trial. The defense indicated there's no suggestion that a statement was made under any duress, such as would form a basis for excited utterance or anything like that.
The victim was the father of her 3 children, is that correct?
Right, there's no question they had a relationship, and the communication that they had, the trial court sort of abdicated its responsibility, with all due respect, in permitting her to testify as to what he had articulated to her. It's clearly hearsay, and it is clearly inadmissible.
You're about 4.5 minutes remaining.
Very well. Thank you.
May it please the court, Richard Cassay representing the state of Ohio in this case. The one claim on appeal in the last claim addressed by counsel was this confrontation / hearsay issue. The record will show that there was no confrontation clause claim made in the trial court. On appeal, there's no plain error argument, and if it had been made in the trial court, and if there had been a plain error argument made on appeal, confrontation goes nowhere, because for all of the argument presented here today, there's not one word as to why what the victim's statements were testimonial under the confrontation clause. Testimonial statements are at a minimum statements that an objectively reasonable observer would think were made in anticipation of a prosecution or some court proceeding. Now, what this victim said was after the cousin Woodall of the 2 defendants here today was killed at the victim's birthday party, Golden was in fear of his life, and he was concerned about Delrico Thomas. That's not testimonial. No way in the world. We get to hearsay. It is clearly not hearsay. The law's been established at least from State versus Panovich that the witness or the out-of-court declarant may express fear and fear of a particular person. That's not hearsay. That is an exception to the hearsay rule. Going even beyond that, there's nothing in this brief as to why this alleged inadmissible hearsay was prejudicial. There's conclusions made here today that is not a showing of material prejudice. So there's no confrontation issue, there's no hearsay issue, and there's no prejudice demonstrated on appeal. Now, going to the sufficiency argument, there was some talk about the car being burned and no forensic evidence. No charge in this case was based on the burning of the car. The tampering was cleaning of the car. The obstruction for Delrico was lying to the police. Now, a reasonable jury could find that it was Delrico and Gracshawn who in fact burned that car, because the car was burned approximately 10 hours after the police came looking for Gracshawn. 10 hours later, this car, which had been, it's almost humorous when you see the pictures, it's partially spray painted. Partially spray painted black over the tan original coat. But that wasn't sufficient, so it was blown up and burned. But getting back to the chain of the evidence on the sufficiency, we have the man outside of the Rally's restaurant sees the rendezvous come up, approach Alfonso Golden's car in his truck, drive up, then slow down, and inside the car, 8 shots are fired. Now, the police thoroughly examined the scene outside Rally's. They didn't find shell casings. So what's going to happen when you fire 8 shots from inside the car? If the casing's got to go somewhere, if they don't go out the window, they're going to be inside the car. So that occurred at 8:33 a.m. on September 18th. 11 minutes later, Gracshawn drives into the 2nd Street location, and this is all on CCTV and viewed by three separate independent witnesses. Gracshawn comes in 8:44, about 9 a.m., Delrico pulls in, and the two of them are there with the rendezvous. They have all 4 doors open, the trunk is open, and they're in there like busy little beavers, cleaning and looking. And then Gracshawn takes a plastic bag, tosses it away. Prior to that, there are calls from Gracshawn's phone, 4 of them, immediately after and immediately prior to Delrico's arrival at 2nd Street. They're communicating. The jury can find that Gracshawn is telling Delrico, get up here and help me. And I also need a ride, because they left together after they cleaned out the rendezvous. The cell phone location. No. The cell phone evidence does not put Gracshawn at the curb outside of the Rally's restaurant. But I can tell you for a fact that if it put him 10 miles away, that'd be a pretty good reason why he would never have been charged. It's relevant. It puts that phone in the vicinity. It doesn't have to put him in that rendezvous outside of the Rally's curb. But it's relevant. The drive from the Rally's restaurant to 2nd Street, well, there's an 11-minute gap between the shooting and Gracshawn arriving at 2nd Street. One of the officers drove that route. Approximately 5-6 minutes it can be done. A defense witness drove it in a little over 11 minutes. So it is not impossible to get there in the time of span measured out by the phone calls and the CCTV. The alibi. It wasn't much of an alibi because the 2 alibi witnesses, one related to Gracshawn and the other a friend of the relative, swore that while he was at I think it was an aunt, while he was at the aunt's home, Gracshawn is making phone calls. They said it more than once. Yes, he is on his cell phone. Gracshawn testifies, and he says, no, I never made a phone call. So what kind of an alibi is that? It's not a very good one. It's certainly not one that any rational jury was required to accept. Gracshawn says he was cleaning out the car because he happens to be in the business of selling marijuana, and he dropped one of his little baggies. Jury wasn't required to accept that. And that has nothing to do with sufficiency anyway, because the state is, the evidence is reviewed in the light most favorable to the state. Credibility of any alibi witness has nothing to do with it. It's relevant in a manifest weight argument, but the primary, even though this court has discretion to view matters of credibility, the jury still has the primary task in sifting through that conflicting evidence. And as I say, the conflicting evidence is worthless, because Gracshawn contradicted his own alibi witnesses. Worthless evidence. BMV. Gracshawn says, well, I was at the BMV paying the reinstatement fee. Too bad for him, BMV had no records of him making any payment. Worthless evidence. The evidence that Gracshawn was the shooter is circumstantial, but it's been established, at least in the Nicely case, that a conviction can be based solely on circumstantial evidence. These two cousins had the motive. That's the death of Reggie Whittle. They had the means, they had the opportunity, and their actions after the shooting are perfectly consistent with Gracshawn being the shooter, Del Rico not charged with a homicide, but helping him clean out that car because it contained the casings and very likely gunshot residue.
And so that I'm clear, the tampering charge for Gracshawn comes only from the cleaning of the car, and not spray painting, not burning?
No charges on burning of the car.
Or spray?
Or spray painting.
Okay, so solely for what is essentially activity that's caught on camera?
Yes, and viewed by 3 witnesses. That's correct.
But the other evidence, the subsequent evidence of the spray painting and the burning makes it into the record?
Oh, it's absolutely in the record, yes, because that was, now this car was driven by Coon, who is apparently the aunt of one of the Thomases here, I think Gracshawn. That was her car, and that's the car that was burned. We know it was because we had the license number, and that's her car being burned.
It comes in as rebuttal evidence?
No, it comes in the state's case. As I say, there were no charges based on burning of the car, but the state believes that they burned the car, even though we didn't charge them with it. But the tampering was solely cleaning out that car, opening the doors, the trunks, going through there very industriously and taking something out of that car. That's an alteration. That's the tampering. That's a modification, that's a change, that is a difference in the appearance and contents from before to after. We know there was something taken out because Gracshawn is seen with his little white baggie after cleaning, and he disposes of that. That's the tampering charge. I don't know how much time I have remaining, but
About 2.5 minutes.
well, if there are no further questions, I'll conclude.
Thank you.
Sure.
In rebuttal of the state's argument regarding the tampering, which is certainly not the most serious case of this, we had also, the state speculates that they were cleaning the car out to remove evidence and ascribed the characteristic of being industrious to my client. He was so industrious, he left the bag sitting by the curb. It was in plain view. The police could have confiscated it. So it does not show any consciousness of guilt or any intent to do anything other than clean out a messy car. If he was that industrious, he probably would have taken the bag and driven it off or disposed of it. So the state is engaging in, has engaged throughout this in fanciful speculation, if nothing to support their argument. I direct the court's attention to, in the, I think it's representative of what was going on with regard to the, we believe, inadmissible hearsay and highly prejudicial. On 201 of the transcript, the state indicates, it stated that the court inquired, what does the purport or the proposed evidence, quote, it shows motive. And clearly that's not an element. As far as whether there was any waiver of this confrontation argument, remind the court of State versus Patel, P-T-E-L, that's argued or set forth on page 11 of the brief, wherein clearly stated that the appellate court reviews de novo the question whether the admission of evidence violated the Sixth Amendment confrontation clause, right? So even if it wasn't properly preserved, which we argue it was properly preserved, this court can review the record and determine that there's a confrontation clause violation. If in fact it wasn't properly presented in this brief, for the record, I did not prepare this brief. If you look at the docket, then we would probably be back here arguing appellate rule 26, ineffective assistance of appellate counsel. But I think it is this court's obligation to review the evidence de novo to see if there is indeed a violation of the Sixth Amendment confrontation clause, which we submit there is, and the damage was obvious, speaking from the grave, and it was testable. One thing very briefly, also argued that there was insufficient evidence to show prior calculation and design to make this an aggravated murder. So we have, in summary, circumstantial evidence which is insufficient as a matter of law, including inadmissible hearsay, which directly violated this young man's constitutional right to due process and violates his right to be able to confront all witnesses against him. He is in jail for life, having been convicted of an aggravated murder. I thank you for your time.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.